everyone. Oh, I was just told, as a heads up, so we're all aware, there will be a gun salute around 11:15 this morning. So I wanted you all to know the same thing that I just learned. All right, then.
To know.
So the lineup I have, I just want to make sure we're all on the same page. 40 minutes, followed by 20 minutes, followed by 5 minutes, 5 minutes, 10 minutes on rebuttal.
20 minutes for the position you're.
You're right. That's why I ask. This is the first time that I've been corrected, but thank you for that. It's really important. So 40 minutes, 20 minutes, 20 minutes, 5 minutes, 5 minutes, 10 minutes. That's it, right? Great. With that, let's proceed.
Morning, Chief Justice Ziegler. May it please the court, Attorney Matthew Tome from Atollas Law on behalf of the defendant appellant, Joel Hermansky. This case is not about what the law on abortion should be in the state of Wisconsin after the United States Supreme Court's reversal of Roe v. Wade and its progeny. This case is about what the law on abortion currently is. It is District Attorney Hermansky's position that applying well-established legal principles previously recognized by this court, Wisconsin Statute 940-04, which was enforced against consensual abortions prior to Roe v. Wade, can now once again be enforced with Roe v. Wade's reversal, and that the position of the circuit court below, which was that 940-04 was never an abortion statute in the first place and only applied to feticide, and that the legislature somehow acquiesced in that position, is ultimately indefensible. Section 940-04 applies to prohibit consensual abortions from conception until birth, subject to an exception when it is necessary to save the life of the mother. It remains on the books. Policymakers have not repealed it. Indeed, they have expressly declined to do so at multiple opportunities, and until they do, it can be enforced. It may be that the citizens of the state of Wisconsin would be better served by a different law, but that is not a question for this court or these parties to decide. It is not this court's role to give the plaintiffs what the legislature has thus far refused to provide, a repeal of 940-04's applicability to abortions. The circuit court relied on State v. Black, which was a decision by this court addressing the application of 940-04 sub 2 sub a to a situation where an individual assaulted his pregnant wife shortly before she was due to deliver the child, ultimately resulting in the death of the fetus. The court in that case determined that 940-04 sub 2 sub a could be applied under that circumstance. In doing so, this court made, I think, what would be fair to say are somewhat conflicting statements. At certain times, the court said 940-04 sub 2 sub a is a feticide statute only. At other times, the court talked about how the question was whether it was only an abortion statute or could also be applied to feticide. But I think the point is this. State v. Black did not overrule this court's prior precedents applying 940-04 sub 1, which we believe is the statute at issue in this case, to consensual abortions. We've cited multiple cases, including State v. McGarren's, which applied 940-04 sub 1 to a consensual abortion. In State v. McGressen's, it said there's three elements to a violation of 940-04 sub 1: a living unborn child, a destruction, and the intent to destroy. We believe this plainly covers an abortion, especially an elective abortion. That's the point of an abortion. It is to intentionally destroy the life of the embryo or the fetus. The life
Counsel, if I may.
Yes.
You started your argument this morning indicating that it's not a matter of what your preference is, right? And you argue that, of course, or advance that in your brief. It's your, in page 14, I think, but it's your position that the language with regard to the statute in question is clear and unambiguous. Is that correct?
We believe it is clear and unambiguous that it would apply to a consensual abortion, yes.
And in that regard, then, if it is clear and unambiguous, is it appropriate to consider the title of the section, or also to consider its legislative history?
I think under Kalal, this court has said that legislative history, even in a situation where the statute is clear and unambiguous, can be used to confirm that interpretation.
That's correct. What about the title?
Title, I think also there are cases that say you can use it to confirm a plain meaning interpretation. I don't think you can use it to create ambiguity, but I also don't think that's what we're doing here. I think what we are doing is we are saying the statute applies to abortion under its plain language, read in context with the rest of 940-04, other statutes on the books, and it was interpreted by this court and applied to consensual abortions in cases that have not been overruled by this court.
There are cases that, with regard to the title, though, say to the contrary of what you're advancing.
In terms of
being able to use it.
The title?
The language is clear and unambiguous.
I believe we cited the cases in our brief that say you can use it. I'm not saying the court has been entirely consistent on its treatment of titles and their use in statutory interpretation, but...
You are not asserting here this morning, are you, that this court is ever inconsistent?
I'm sorry, I missed...
Never mind.
Don't answer.
Yeah. Okay, that's all. Thank you.
Oh, thank you. And I guess on the legislative history point, Justice Bradley, I just want to emphasize another point from our brief, which I don't feel like was ever really rebutted, which is 940-04 was a revisor bill. This was not a new statute based on new legislative history. This was a statute in which the legislature revised the current criminal code in the mid-1950s. And Section 990-001, sub 7 of our statute says you can consider revisor's notes. That's not ordinary legislative history. So our position is that the statements that accompanied the revision of the criminal code in the mid-1950s, you can take into account the Legislative Council's discussion of what those statutes were intended to do, and they said this section penalizes the person who performs an abortion on another, and this section is a substantial restatement of the present law. And I don't think anybody would deny that the laws on which 940-04 were based were laws that were applied to abortions. I mean, that's all we've heard about this statute, is that it's an 1849 abortion ban.
Mr. Tomey, I want to ask you some questions that the amici brought up. And I want to start with the American College of Obstetrics and Gynecology. Under your interpretation of 940-04, there would not be an exception for sexual assault or rape, correct?
I believe that is correct, unless it was necessary to save the life of the mother, or two doctors said it would.
There would not be an exception for incest, correct?
I believe that is correct, unless 940-04 sub 5 applied.
There would not be an exception for the health of the mother, correct?
I believe that's correct, unless it's 940-04 sub 5 applies.
There would not be an exception for a fetal abnormality, correct?
I think one of the elements for a violation of 940-04 sub 1 is that it is a living unborn child, so I guess it would probably depend to the extent of the fetal abnormality. If it's a situation where in the death of the fetus, I don't think you could apply this statute.
Let me drill down a little bit with some specifics on these. Just to be clear, a 12-year-old girl who was sexually assaulted by her father and as a result became pregnant, under your interpretation of 940-04, she would be forced to carry her pregnancy to term, correct?
I would say under the policy choice the legislature made in 940-04 that would be correct.
Okay, so in that case, a child would be forced to deliver a baby. Let me ask you another question. How about a woman who is a college freshman here at the University of Wisconsin-Madison? If she is sexually assaulted and is charged as a third-degree sexual assault, which under the statute, under 940-225 sub 3A, that would be intercourse without consent. Okay. If she became pregnant as a result of the sexual assault, it would be illegal for her to obtain an abortion, correct?
It would be illegal for a doctor to provide an abortion to her in the state of Wisconsin, correct.
And were she to obtain an abortion after quickening, whatever that means, the penalty under 940-04 would be 15 years. It's a Class E felony, correct?
Are you talking about after quickening under 940.04 sub 2 sub A?
Yes.
I believe that's how it's defined, yes.
Okay.
But it would not be, she would not be subject to that penalty.
I understand. Right. If her assaulter is charged under 940.225 sub 3 sub A, which is a third-degree sexual assault, he would be facing a 10-year maximum imprisonment because that would be a Class G felony. Is that correct?
I'm not sure what the particular penalty associated with that crime
All
is.
right, you can take my word for it. In that case, the penalty for aborting after a sexual assault would be more severe than the penalty for the sexual assault. And the local elected officials, amici, cite an article from the Journal of the American Medical Association that estimates that 65,000 pregnancies have been caused by rape in the 14 states that outlawed abortion after Dobbs. So the scenario is far from speculative. I want to discuss one more scenario with you, and that concerns the health of the mother. The term pre-prom, do you know what that means? Preterm, premature rupture of membrane. Again, one of the amici, the ACOG amici, brought up the case of Joseli Barnica, who went into premature labor at 17 weeks. That is, her water broke. There was a fetal heartbeat, but her fetus was not yet viable. This happened in Texas. She suffered an infection that killed her because medical providers were unwilling or unable to give her the health care that she needed. And all she could do for 40 hours was pray that someone would help her so she could go home to her young child. And she died. That is a scenario that could easily, and perhaps has easily, played out here in Wisconsin under your interpretation of 940.04, couldn't it?
I'm not sure, Justice Karofsky. I'm not a doctor, and I would say that the interpretation of 940.04 that we're positing is the legislature's judgment as to what the law should be. I would like to circle back, though.
No, hold on, I'm not done.
Yeah.
I can't think of anyone else other than pregnant people who are denied medical care under the law. Can you?
I certainly think that, for example, the FDA regulates particular types of medical treatment that are provided to people. I don't think that the notion of the government restricting a medical procedure is new, but I also think that there's a long-established history in this state of prohibiting abortion.
Mr. Tomey, and I fear that what you are asking this court to do is to sign the death warrants of women and children and pregnant people in this state, because under your interpretation, they could all be denied life-saving medical care while the medical professionals who are charged with taking care of them are forced to sit idly by. This is the world gone mad. I don't understand how that is not the crime here.
Counsel, you're not advocating for the policy choices that the people of Wisconsin have chosen through their elected representatives, right? You're just asking us to construe statutes.
That's correct, Justice Bradley. All we're asking is that this court apply a policy decision that the legislature made via the statute that it put on the books.
Okay, let's talk about the policy decisions that the legislature made. You're talking about policy decisions made in 1849.
That's
right?
not correct, Justice Dallett. I'm talking about a policy decision made in 1955, which was the last time this statute was enacted by the legislature. And I'm not aware of any rule of law that this court has posited.
Revising of a statute is not the enactment of a statute. That's absurd. And that was 106 years after this law was passed.
So in 1849, we're talking about a time when the only people that had rights were white men, correct? With property. White men who own property, sorry. Is that right?
I'll take your word for it, Justice Dallett.
Okay, well, you can take my word for it. You can go look up when anyone else got rights.
And women had full civil rights in 1955, did they not, Counsel?
I'm asking the question
I
right
don't
now.
think
I'm
they were
asking
able
a
to have their own
question,
credit.
So, in 1849, at the time that this policy choice that you keep referring to was made, since that time, and let's go past 1955,
We have statute after statute that you are somehow asking us to just absolutely ignore in your interpretation. We have a statute that was 253-107 that talks about when an abortion can be performed, and that's after 20 weeks. We have a 24-hour waiting period statute. We have informed consent provisions. We have a ban of what they label to be partial birth abortion. We have a requirement about what a physician has to do in terms of admitting privileges. We have when a physician can provide a medical procedure, and on, and that's not even 940-15. So what about all those policy decisions? What about everything that's happened since 1849 in the policy choice that you're talking about that some white men who were property owners made?
Well, I guess my response to that would be it's essentially the same issue that was put to the Arizona Supreme Court, Justice Dallett. And I think in that case, for example, things like informed consent, that type of thing, the Arizona Supreme Court said that could still have an effect in a situation where abortions are provided in situations where it's necessary to save the life of the mother.
Can you imagine trying to provide informed consent to a 12-year-old?
I'm sorry, Justice Croft, because I missed the first part of that
question.
Can
you imagine trying to provide informed consent to a 12-year-old who is in labor? I will just tell you from my own personal experience, as an adult, trying to understand the options when you are in the middle of labor is way too much to wrap your mind around. And we're talking about 12-year-olds here.
And Justice Karofsky, I do think there are parental notifications and parental consent statutes in that scenario. But again, what we're talking about here are policy choices made by the legislature. I mean, these arguments could all be made to the legislature, and if the legislature decided to do so, it could change the law.
But it did change the law. So 253.107, how do you possibly reconcile that statute? You're asking us to read a statute that basically prohibits abortion. It does. It prohibits abortion, period, point blank, stop. And then we have 253.107 that says that you can have an abortion as long as it's not after 20 weeks. And then there's a whole scheme of how that happens with the doctor's privileges and the waiting period and all that stuff. How do you fit those things together?
Well, I fit those things together, Justice Dallett, because that statute doesn't say you can have an abortion.
Okay,
No, Justice Dallett, it creates a crime, and it defines the elements of the crime. And the reality of the situation is that argument is essentially the argument that this court rejected in Granbury, where somebody came in and they said, I've complied with the safe transport statute. The safe transport statute says I can carry a handgun in my car. According to the Attorney General's position, that is a signal to the world that that is lawful conduct, and it therefore creates a conflict with other statutes that would prohibit that conduct. That's not right. That's not what this court said in Granbury. Granbury said you only have a conflict if it is impossible to impossible to comply with both statutes. It is possible for a doctor to comply with 940.04 and all of the statutes you referenced.
But the only way they do that is if 940.04 swallows up the rest of the statutory scheme.
Justice Karofsky, that's the case with every single included offense. If you look at the statute that defines included offenses, an included offense is an offense that does not require the proving of an additional fact.
I'm well aware of how lesser included.
Counsel, I've got a question.
Go ahead, Justice Bordzewicz.
Thank you. Counsel, I've got a question for you about DA Chisholm's submissions in this case. And he talks about prosecutorial discretion. If, in fact, we would resurrect this particular statute and find it to be an abortion statute, do you agree that the DAs around the state have the discretion as to whether or not to charge someone under that statute?
Justice Bordzewicz, I would agree with that. I think this court has recognized wide-ranging prosecutorial discretion in the states so long as you're not doing it in a way that violates equal protection.
Counsel, I'd like to return to a statement that Justice Dallett made to you. Are you aware of any principle of law that instructs judges or justices to disregard an enactment of the legislature based on the race or gender of the enactors?
I am not, Justice Bradley, and I'm not aware of any such enactment that says you should disregard a statute based on how old it is.
And Counsel, do you think that 940.04 sub 1 can be both an abortion statute and a feticide statute?
I think it could. I think you could apply it to both, and I think that's why what this court did in State versus Black was ultimately dicta when it talked about how this couldn't be applied to a consensual abortion. It didn't need to go there. The court could have just stopped its analysis at saying, yes, you can apply this statute under these circumstances. But as soon as it went into talking about its applicability to a consensual abortion, you're talking about a factual situation that wasn't in front of the court, and that's a definition of dicta under this court's precedence. And
Counsel, I want to return to one of the arguments you made earlier about McGreeson's. I understand that the point you to be making is that this court has already authoritatively construed 940.04 sub 1 to be a statute that prescribes abortion, correct?
It has certainly upheld applications of the statute to consensual abortions and defined the elements of the statute in that process in a way that applies to consensual abortion.
And Black said it was only applying to 2A, was not making any effort to disturb anything with 940.04.1, despite requests to do so in that case, correct?
That's correct, Justice Hagedorn.
And so it would seem to me that if that if you were to take Black's construction, even at face value on 2A, you would have to overrule cases and make some argument that a text that basically every case in Wisconsin up until Black had, looked at this language. Well, every case in construing sub 1 made clear it was about abortion up until then with, literally dozens, I guess, or a dozen or so or more, right?
Yeah, that's correct, Justice Hagedorn. I think that was a point we made to the circuit court, which was actually applying the wrong precedent.
Counsel, your prior response rested in part on an assertion of dicta. Are you aware that this court, at least as we speak today, indicates that our opinions don't have dicta?
Justice Bradley, I'm aware that this court has said that in the context of the Court of Appeals applying this court's decisions. I think Justice Hagedorn, Justice Dallett, your Wisconsin Justice Initiative concurrence takes a deep dive into this issue. And I believe, Justice Hagedorn, you make the point that nothing in Zarder says this court can't treat its prior opinions as dicta.
Let me point out to you that that's in a concurrence.
Justice Bradley,
a good one.
A really good one.
Justice Bradley, I am aware it is a concurrence, but I also, when I read the Zarder decision, I don't see anything in the Zarder decision that says this court.
One of the first things I learned when I got on this court is 1, 2, 3, 4, right? How to count to 4 to get to a majority. And thus far, that is the majority of the court. Is that correct regarding dicta? If you know the answer to that.
I don't think that's the majority of the court, Justice Bradley. I think Zarder says the Court of Appeals can't.
What case can you point to that says what you're asserting vis-a-vis that we indicate that, yes, there is dicta in our opinions?
Well, I think there was a long line of precedents from this court recognizing the role that dicta played. I think
currently, I mean, we may have been inconsistent in the 1920s and 30s and 40s, but at least since I've been on the court, that's been the position of the majority opinions of the court.
I think it would be fair to say that, and I think Justice Hagedorn points this out in his concurrence, that this court has stopped talking in terms of dicta. I would agree with that, but I don't think that's what this court held in Zarder. I think this court held in Zarder that lower courts, the Court of Appeals, can't treat statements from this court in its own opinions as dicta.
Your argument about Black is not predominantly dicta. It's that it was, number one, it doesn't extend to sub 1, and this court has already held sub 1 applies to abortions. Number two, the statutes pretty clearly do apply to abortion. And so number 3, that it was wrong. And so number 4, the alternative, that was just dicta anyway, right? I mean, that's your alternative arguments on the way you're playing that out, not your primary argument, correct?
Yeah, Justice Hagedorn, I think there's probably 4 or 5 points with respect to Black. I think you hit on most of them. One, it's not interpreting 940.04 sub 1. 2, we think its discussion of the applicability of 940.04 sub 2 sub A to a consensual abortion was dicta. 3, we think that discussion was unsound in principle. In the Waukesha County versus MAC case, this court recently decided, I believe earlier this year, this court said a decision is unsound in principle if it does not undertake a comprehensive examination of a statute or overlooks relevant subsections. I mean, frankly, I think State versus Black was pretty explicit about the fact that it wasn't undertaking a comprehensive examination of the statute and wasn't looking at all the relevant subsections of the statute. And I guess the last point I would like to make with respect to State versus Black is even if you take all of that away, what does State versus Black say about conflict and application of 940.04 sub 2 sub A to a pre-viability abortion? It doesn't say applying 940.04 sub 2 sub A to a pre-viability abortion would conflict with subsequent statutes. It doesn't say that. It says the only thing holding back an application of 940.04 sub 2 sub A to a pre-viability abortion is Roe. And Roe's been overruled. So I would say even under State versus Black, there's an indication that 940.04 sub 2 sub A could be applied to pre-viability abortions. Why couldn't 940.04 sub 1 be applied to pre-viability
So unlike
abortions?
other states, Wisconsin did not pass any kind of trigger, what are we call trigger laws. Is that correct?
That's correct.
So, and they could have. The legislature absolutely, in passing all of the statutes that it passed, could have indicated that should Roe be overturned, these statutes are no longer in effect.
I don't think it was necessary, Justice Dallett, and here I would refer the court to...
Well, other states did and have, and certainly have since Dobbs came along, correct?
Justice Dallett, I'm sure other states have passed trigger laws. I'm not familiar with what those other states had on the books from their prior statutes at the time
Okay,
they
and how
passed
about
those trigger
even
laws.
West Virginia, which actually the court held that all of the statutes have changed the law from what it initially was, that is a very similar statutory scheme of comprehensive statutes that allowed for abortion since Roe was the law. The court upheld all of those and said to the legislature, if you want to change it, you can, and they did. So the legislature still has the ability, if they wanted to do something, to do it. But again, you're still asking us to ignore an entire body of law that has been passed that doesn't say we're only passing this because of Roe. I mean, Roe did not require 20 weeks. I have a hard time with your argument, specifically with respect to 253.107. Roe talks about viability. 20 weeks is pre-viability, and our legislature decided fairly recently, at least in the scheme of these regulations, that an abortion may not be performed after 20 weeks unless the mother is undergoing a medical emergency. That's not based on Roe. That is the legislative policy that was chosen by this state's legislature.
Justice Dallett, I would say that statute was passed while Roe and his progeny, including Planned Parenthood versus Casey, which actually changed the Roe standard a little bit, were the governing law of the land. But I think the point remains.
So are you saying that any law regarding abortion that the Wisconsin state legislature passed after Roe was decided in 1973 and up until Dobbs was decided, that all of that body of law, all of those statutes regarding abortion, just go to the dust pile?
No, that's not what we're saying at all,
It is what you're
Justice
saying, because you're saying that if they were passed after Roe, and if they were passed with Roe in mind, then they mean something different today than they meant before Dobbs.
No, it means those statutes had a different purpose, which is one of the things this court looked at in State versus Granbury. We're just making these same arguments.
What's their purpose now?
What was the purpose of 253.107? Can you tell us? And since when do we actually look at when do we look at the intent of the legislature and try to decide what one legislature wanted versus another? But tell me, what's the purpose of 253.107, a 20-week ban enacted in 2015?
I would say the purpose of that was to regulate abortion within the strictures that the United States Supreme Court had put into place after Roe up through Dobbs. And the reality of the situation is, under this court's precedent, State versus Granbury, you don't have a conflict between two statutes unless it is impossible to comply with both statutes.
You don't.
Now,
Let's go through some examples of how it's impossible to reconcile these, okay? Let's look at 940.04 sub 1. It prohibits abortion from the time of conception until born alive, yes?
correct.
Okay. How about 940.15 sub 2? When does that prohibit abortion?
Is it 940.15 sub 2? I believe that's post-viability.
Yes. So if you are a medical provider, what in the world are you supposed to do with that? That those statutes are in conflict.
Respectfully, Justice Karofsky, they're not. They're not in conflict any more than an included offense is in conflict with another offense that establishes additional elements for a crime.
I fear you don't understand how lesser included offenses work. Let me ask you about, let me ask you a different example. How about 940.04 sub 2 prohibits abortion of an unborn quick child, right? And I'm not exactly sure what a quick child means, but whatever. That's what the statute from 1849, unsurprisingly, because we know a lot more about medicine now than we do then, but it talks about a quick child. 940.15 sub 1 defines viability as that stage of fetal development when in the medical judgment of the attending physician, based on the particular facts of the case before him or her, there's a reasonable likelihood of sustained survival of the fetus outside the womb. Are those different? Is a quick child the same, or is it different than the definition I just gave you of viability?
I think it's probably fair to say that it's different. I believe quick child was defined by this court in State versus Timms, Foster versus State, as the moment at which you feel the movement of the fetus in the womb, which is roughly 4 to 5 months. Now,
is it? What if you don't feel it at 4 or 5 months? What if I didn't feel it at 4 or 5 months? What if someone goes into the emergency room and they're not feeling it at 4 or 5 months?
Well, Justice Karofsky, I think you can think of any number of examples, but what you're really hinting at here is that it's a vague statute. But vagueness doesn't require mathematical precision. That's very clear from this court's precedents.
Mathematical precision? Are you kidding me? We're trying to figure out if medical providers here are going to be able to save women's lives. So yeah, we better get this right.
Justice
Karofsky. So hold on. Okay, what I'm asking you is, what is a medical provider supposed to do when they have to figure out whether or not it's a quick child, whatever that means, or they've reached the viability definition in 940.15 sub 1? I don't understand from your argument. Like seriously, what are they to do?
Justice Karofsky, a medical provider who conforms his or her conduct to 940.04 sub 1, doesn't have to answer those questions. And that's why this is not a question of this statute being unconstitutionally vague. And I understand what you're hinting at right here is sort of the vagueness of the statute. But I guess on that I'd make a couple of points. One, this is a facial challenge to the statute, and it's being brought by a doctor who acknowledges that she performs elective abortions. Under this court's precedents, State versus Wood, you don't even get to these hypothetical examples unless the statute as applied to the particular physician would be unconstitutionally vague. And the fact of the matter is that all of the vagueness arguments that have been raised regarding the definition of quick, or whether or not something is necessary to save the life of the child, or those types of issues, they don't apply if you're talking about a consensual elective abortion for an otherwise healthy mother. And on that I would make 2 points. This court is very clear that when you're talking about a facial vagueness challenge under the state standard, now there's a difference between the state and the federal standard that's teased out a little bit in the briefs, but under the state standard, if there's any possible application of the statute that would be constitutional, it passes the facial challenge.
I'm not talking about the facial challenge or vagueness. I am talking about the fact that these two statutes are irreconcilable, and that under your interpretation, we are leaving the decision up to hospital ethicists and hospital attorneys instead of medical providers. And that concerns me greatly.
And Justice Karofsky, I just don't think the statute's irreconcilable. I think if this court applies State versus Granberry, these statutes aren't irreconcilable. All you have to worry about is whether or not a physician can comply with both statutes. 940.15 doesn't say a physician has to perform abortions. It doesn't. And the fact of the matter is, 940.04 sub 1, if you conform your conduct to 940.04 sub 1, you will not violate 940.15, you will not violate the 20-week ban, you will not violate the partial birth abortion ban. You cannot be criminally prosecuted in the state of Wisconsin if you conform your conduct to 940.04 sub 1. And because there is a way to comply with all of those statutes, they don't conflict. That's State versus Granberry. This court has been very clear.
So with respect to the feticide component of this statute, are you also trying to tell us that that has not been impliedly repealed?
Which portion, Justice Dowd? I apologize.
If this applies to feticide, which you're saying it applies to feticide and abortion, are you saying to us today that 94004 is the feticide statute that is in effect on the books right now if someone were to commit feticide.
I do know the legislature passed subsequent feticide statutes. I think the question of the effect of those subsequent feticide statutes on this particular statute and its application to feticide is not an issue that's been briefed.
So, to be clear, just as the legislature has passed numerous statutes since 1849 with respect to the abortion, what you say is the abortion portion of this statute, with respect to feticide, almost every single homicide statute, first-degree intentional, first-degree reckless, second-degree intentional, second-degree reckless, and on, has specifically added a provision with respect to feticide. So is 94004, is this still on the books? Like sub 1, we're talking about 94004 sub 1. Is that still a feticide statute, which is a Class H felony, which is a totally different penalty than much of the rest of that's been passed since 1849? Like, what penalty should we impose for someone who commits feticide?
Justice Dallett, I think it is very clear that prosecutors have discretion to charge multiple crimes when multiple statutes might apply. And
okay, it's the same crime, it's a feticide. So which one would apply? 94004 that you tell us is good law from 1849, or whatever most recent statute applies? And I'm not talking about lesser included offenses here.
And Justice Dallett, I don't have the subsequent feticide statutes in front of me. All I can tell you about the subsequent feticide statutes is that they lumped 94004 into a group of statutes that apply to induced abortions. So even when the legislature passed those subsequent feticide statutes, it referred to 94004 as a statute that would be a statute that has some application to induced abortions. Now, can we divine from that legislative intent that the legislature understood 94004 to be just an abortion statute as opposed to an abortion and a feticide statute? I don't know. But I don't know that whether or not those subsequent feticide statutes have impliedly repealed the application of 94004 to feticide has anything to do with whether or not 94004 can apply to a consensual abortion.
Well, doesn't it have something to do with the argument that's being made on the other side about what implied repeal is? You've spent a lot of time talking about conflict, and you do acknowledge that there is a whole other way that the legislature does things, and they do it all the time, and they do it all the time in criminal law, especially where they pass later statutes that have different penalties, that do different things about the same subject matter, and we use those later statutes because we understand that they've impliedly repealed the earlier ones. So I do think this applies to the argument of implied repeal.
And Justice Dallett, I think the legal principle you're making is that you can find an implied repeal when a later statute covers the whole subject and is plainly intended to be a substitute. Now, our position is nothing in those later statutes indicates a plain intent to be a substitute for 94004. Why do we know this? Well, we know when they passed 94015, we know that an early draft of the bill would have expressly repealed 94004, and they took it out.
Well, if you're going to do that, it also had a provision taking out something saying this is not an implied repeal, and they took that out too. So your argument on that one is not so strong.
Well, I would disagree, Justice Dallett, because when we're talking about implied repeal, that's a heavy burden for the challenger claiming that an implied repeal has occurred. The tie goes to the runner here.
Well, the language was in it both. It's hard for us to look at what legislatures do and don't do when they don't pass. So what else do you have?
Well, and I would also say that many of the additional statutes on which you rely have the language talking about how it's not intended to make lawful an abortion that is otherwise unlawful. I mean,
where is that language?
That language is in, I believe, 25310.
Which was passed at the same time as 940.15, so wouldn't that refer to 940.15?
I don't think that's true. I think what the legislature is saying there is in a conflict between this statute and a statute that makes abortion unlawful, you shouldn't be relying on this statute, which just talks about things like informed consent, things like that, to make lawful something that is otherwise unlawful. This is the exact same language that appeared in the statutes the Arizona Supreme Court recently said it didn't constitute an implied repeal, in large part because of that language. It's
it actually says that, there's no other way to read it other than 940.404 must apply to abortions, or else that wouldn't make any sense, because it actually cites that statute, correct? In that language? Doesn't it explicitly state that shall not be construed to say to otherwise permit, in other words, impermissible abortion, and cites 94404 as one of those types of statutes?
I don't think it specifically identifies 94004 in the statute. Referring Justice Hagedorn.
Okay, all right, thank you for the
correction. That's not correct.
Yep.
Okay, so we leave hanging the fact that implied feticide, you're saying that is not impliedly repealed despite having all the statutes that impliedly repeal it.
Justice Dallard, I'm not giving you an answer on that. I'm not giving you an answer on that question because frankly, sitting here today with an issue that hasn't been briefed, I don't have an answer for you. That's not an issue before the court.
Yeah.
Page 39 of the brief of Attorney General Cowell has a response, it seems to me, with regard to new and subsequent legislation in essence, and you don't necessarily have to have it in front of you. If you wish, you can. Their punchline is this, that the legislature created new laws with an exception, but left already listed statutes unaffected by the new exception, further supports, not detracts from legislative acquiescence.
You're talking about the legislative acquiescence argument?
I'm talking about what the enactment of subsequent legislation says about the statute before us today.
If I understand that portion of the Attorney General's brief correctly, I believe they were making an argument that after State versus Black, the legislature passed subsequent laws that didn't affect State versus Black's interpretation. And my time has expired. Can I continue with a brief answer?
You may answer the question.
I believe the argument they were making was that the legislature acquiesced in the State versus Black interpretation. And I guess I would just make three brief comments on that. One, since State versus Black didn't interpret 94004 sub 1, I think it's a real stretch to say they acquiesced to an interpretation of 94004 sub 1. And two, this court has been very clear that if an interpretation is unsound in principle, legislative acquiescence can't be relied upon to force that type of interpretation.
Thank you.
I'll let them respond to that argument when they're done.
Madam Chief Justice, and may it please the Court. The question is whether 94004 sub 1 is enforceable so as to ban all abortion in Wisconsin except those necessary to save the pregnant woman's life. The reasons underlying why the answer to this question is a resounding no go to the very foundation of the rule of law in Wisconsin. The rule of law requires the government of Wisconsin, through our written laws, to provide clarity to the people as to what is and is not subject to criminal punishment so that the people may know before they act. And among other things, the state of Wisconsin cannot have two laws on the same subject with the same scope that provide directly conflicting answers as to when conduct is and is not a felony.
So your friend on the other side says, don't worry about that. This is just an application of the way we use lesser included offenses, and he keeps going back to Granbury. Can you respond to that argument?
Absolutely. So this is not at all a circumstance of lesser included offenses. Lesser included offenses, we're talking about conduct that is illegal under both statutes where the greater requires proof of an element that the lesser does not. This is not that circumstance. And Granbury is dispositively distinguishable because this court's decision in Granbury rested on its conclusion that the two statutes at issue that had overlapping factual subject matter served distinct purposes such that it was not only possible to comply with both, but necessary. And the reason why that's different than what we have here is because 94004 sub 1 and 94015 sub 2 would be doing the exact same work if both applied to abortion. They would have the same subject matter, they would have the same scope. Both would provide the gestational point after which abortion is criminally prohibited in Wisconsin, and they would provide exceptions after that point, but they would provide directly conflicting answers as to both questions.
I'm not so sure that under their argument 940.15 does any work.
You're exactly right, Your Honor. And that's why the discussion of Granberry, the discussion of whether it's possible to comply with both, is incorrect. The possibility question asks whether it's possible to comply with both statutes standing in force, as this court said in Dairyland, i.e., for both statutes to actually be doing work as statutes.
I think that sometimes we can get a little caught up in like a real formalist if these statutes were presented to a person without any context, we might think, it doesn't make a lot of sense, right? Why would you have a statute that prohibits all abortions, except for the life of the mother, and why would you have a statute that only prohibits abortions after 20 weeks? But it just seems a little odd. We all know what happened here. Mm-hmm. We had a law that the people enacted that prohibited abortions, and everybody understood this was about abortion. We have case upon case upon case confirming this was about abortion. The language prohibiting the intentional destruction of unborn life obviously applies to abortion. And then the Supreme Court creates a new right that had not been recognized before, overruled the abortion laws of nearly every state in the country, and now has said we made a mistake, we got it wrong. During that time, states like Wisconsin passed all kinds of laws to do whatever the Supreme Court would let them do, which was a bit of a shifting sand because the Supreme Court had a standard, undue burden, that had no real clarity about it. And first it was trimesters, and then it was viability, and what things you could do or not do was left up in the air. So we all know what happened. It's not like we need to put blinders on and pretend that we got these things in a vacuum. So the question for us is simply does a law that was unconstitutional at one point after 100 plus years of enforcement somehow get written off the books because the legislature tried to do whatever the courts would let it do during the period of the time that the law was deemed unenforceable? So it strikes me that some of this formalist, we've got these things that conflict, we all know what happened. So unless there's some conflict, the laws were not reversed off the books. I don't know why, as a matter of straight, just reasonable statutory interpretation, the law's still there. It's still there. The judiciary doesn't get to edit laws. The judiciary doesn't get to rewrite them. We didn't delete it. We prevented its enforcement. Now it's still there. How can we just say, we can't enforce it anymore, simply because the legislature was doing other things when it was unenforceable?
So I have a number of thoughts in response. So first and foremost, what we're doing here is we're confronted with circumstance in Wisconsin law where we have directly conflicting answers. And so now it's a question of implied repeal, and there's nothing in the text of the Wisconsin statutes that would explain why we should do the opposite of implied repeal, which is to say that under standard rules of implied repeal, when there is an irreconcilable conflict, or we have the second form of implied repeal at issue here as well, that the standard implied repeal rule is it's the earlier law that falls. And there's nothing in the text of the Wisconsin statutes, the text being what governs the conduct of the people and actually applies to the people, that would say disregard all of that and instead, in the event of Roe being overturned, go back to 940.04. And we know state legislatures knew how to do this because, as discussed, a number of states enacted trigger bans. Wisconsin did not. And to push back against Ermansky's reliance on the Arizona Supreme Court case, that case is dispositively distinguishable for multiple reasons, but most significantly because in that case, the modern law contained an express provision that said that the modern law cannot be read to repeal implicitly or otherwise The archaic ban, that in combination with a statute in Arizona that required the construction of any provision to provide as much protection to the unborn child as possible, with the only limiting factor being the United States Constitution, to the Arizona Supreme Court created a trigger ban. That is nowhere to be found in the state of Wisconsin. There is nothing in the text of these statutes that say, in the event that Roe is overturned, we somehow go back to the old law and throw out all of the new ones.
The normal rule, though, is that if a statute is unenforceable, and then the judicial rule would lift that lack of enforcement ability, that rule would go into effect. I mean, that happens all the time, not necessarily for the duration that Roe did, but that Roe occasioned, but I mean, it's not unusual to have a statute that is unable to be enforced for a period of time. It doesn't get deleted.
Well, you're correct that a court rendering a statute unenforceable has not scratched it out of the statute books, but where that decision then is overturned, we're just back to statutory construction, and statutory construction requires in this circumstance implied repeal, which means that it is the earlier law that falls, not the later.
But your argument isn't giving effect to the legislature maintaining the pre-Roe abortion law in the books.
Can you say that one more time?
Sure. Well, I'll put it in the form of a question. I don't think your argument is giving effect to the legislature maintaining the pre-Roe law, the abortion ban, on the books.
I disagree with that. If the fact that the legislature didn't expressly repeal 940-04, right, we don't need to consult legislative history to tell us that. We can see that it's still listed in the statute books. But what the legislature did do is enact a number of modern laws, most notably 940-15, that sits in the exact same spot, does the exact same work that 940-04 would do. And as Your Honor knows very well, when there is conflict into the law and lack of clarity as to what is and is not subject to criminal sanction, we have to provide that clarity. The court has to provide that clarity, and the way that it does that is by recognizing that the earlier law has been impliedly repealed.
But your argument is asking us basically to put blinders on. I think this was the point that Justice Hagedorn was trying to explore with you. It was not as if the people of Wisconsin decided of their own accord to enact this post-Roe regulatory regime, changing the abortion ban to something else, right? Are you asking us to ignore the fact that the United States Supreme Court forced those regulatory regimes on people all over the country?
I'm asking the court to read the text of the statutes based on the text and to see if there is a way to reconcile these statutes based on the text. This court already said, recognized in Black, there is not, and so it looked for any way that it could harmonize the statutes, and there it recognized feticide. And just to push back a little further on that, are we really going to say, for example, that Wisconsin's statute that prohibits racial segregation in schools is contingent on the existence of Brown v. Board? Are we really going to say that Wisconsin's entire statutory structure for the provision of indigent criminal defense is contingent on the existence of those decisions? No, that's not how we interpret statutes. And so now we are back in a position where we have to look at the statutes that govern the conduct of the people of Wisconsin, and what we have are directly conflicting laws. And we know this, again, because 940-15 sub 2 would be doing absolutely no work as a statute. No work, none, 100% superfluous if 940-04 sub 1 were also enforceable as to abortion.
Are you asking us to overturn Black, which expressly disclaimed your entire argument about implied repeal with respect to these statutes?
No, we're not. Black, in fact, resolves this entire case because the language of Black that this court interpreted there is materially indistinguishable, and this court was doing the exact right thing in Black, which is it looked at two statutes that would appear to conflict, and it asked, instead of concluding that the older one had to be fully impliedly repealed, it said, hey, based on the text, can this statute be doing any work? And it said that language that prohibits the intentional destruction of an unborn quick child by anyone other than the mother could be doing work as a feticide statute. And so we think that decision was correct, and he has not presented any reason for this court to distinguish it or overturn it. But if you disagree, we're back to the same conclusion, which is that 940.04 has been impliedly repealed.
Attorney Durst, on page 26 of your brief, you talk about Black, and you write this: in reaching its holding, this court in Black stressed that the reason 940.04(2)A could not be understood to apply to, this is in quotes, a physician performing a consensual abortion after viability, after quotes, was that such application, and again in quotes, would be inconsistent with the newer section 940.15, which limits such action and establishes penalties for it. And then you cite Black at 646. Is the court there talking about implied repeal without talking about implied repeal?
Yes, that's so. Exactly what this court was doing was saying, okay, we have two statutes, 940.04 sub 2A there and 940.15, that appear to conflict. And so we, as the court, have a responsibility to determine whether there's any way the statutory language of the older statute, which would otherwise be impliedly repealed, can still do work. And when you look at the text of 940.04, it makes sense that it could apply to feticide.
And if we agree with your argument regarding implied appeal, would 940.04 still be in effect as a feticide statute?
It could be. And the reason that it could be is because when we talk about what constitutes actual permissible overlapping criminal statutes, it's where the conduct is illegal under all of the statute, but you might have different factual circumstances. And so when we look at that, right, just to use an example, someone goes into a bank and robs it at gunpoint. That single factual act is illegal under multiple criminal laws. Or consider the facts of Batchelder, which is the seminal overlapping criminal statute case. There, two federal laws prohibited felons from receiving firearms, but there were different penalties imposed. In both of those circumstances, the public has notice as to what is and is not subject to criminal sanction. That would not be the same if 940.04 and 940.15 both applied to abortion. And to quote from Radzenauer, which is the precursor case to Batchelder, implied repeal occurs if necessary to make the later enacted law work. 940.15 sub 2 would be doing no work at all. There is no circumstance where a physician could be performing a non-life-saving abortion pre-viability or post to protect the woman's health that wouldn't be a felony under 940.04.
It just feels like it's a little bit of the tail wagging the dog on this. You know, you have a policy choice by the legislature that says you can't do A, B, C, and D. And a court comes in and says, we're not going to let you enforce the prohibition against A. And the legislature comes back, or any of it, and the legislature says, okay, fine, we're going to prohibit B, C, and D. And then the court comes and says, okay, that's fine, you can do A, B, and C, and D if you want. And it's almost like because the legislature was working within a judicial regime that prohibited it from doing everything that it had passed in a previous statute, that you're now going to use that to say it overrode what it had previously already decided and still left on the books quite intentionally. So again, this isn't a situation where this comes out of nowhere, that the legislature was prohibiting all that it was permitted to or as much as it could in many situations, under the Supreme Court shifting standards during the Roe-Casey timeframe. So I don't understand why you would say just because the legislature did everything a court allowed it to do, that now that is the only law, that it somehow repealed everything it intentionally left on the books before.
So Your Honor's question, I think, is incorporating a lot of guesswork and assumption about why the legislature in the state of Wisconsin did what it did. And this isn't to say that we don't know the history of what was happening, right, and the existence of Roe, but it is to say that when we construe statutes and whether or not they conflict, we don't go to just guesswork about what the legislature may have intended. We interpret the statutes of the text that the legislature already wrote, and you will not find in the text of 940.15, you will not find in the text of any of the other modern statutes anything that makes clear that these statutes exist only as long as Roe exists, and we know that legislatures knew how to do that. And
Do you think it's guesswork to suggest that the legislature addressing parental consent laws using the word viability, which the court in Casey announced and brought up, 20-week bans, which were pretty, I mean, this is not, we all knew what was happening, and this is not, it's sort of like saying the public health laws which arose in the Spanish flu of 1918, we can forget that they were about the Spanish flu. Like, we all know what happened. It's okay. We're not speculating here. I mean, the legislature was working within a framework that had a bunch of shifting sands about viability, about date limits. I mean, that's what it was doing. We all know that.
But Your Honor's question presumes that the only reason why the legislature of Wisconsin was doing that was because of those restrictions, as opposed to also the people of the state of Wisconsin understanding and enacting through their...
But your argument is that the legislature, you're speculating the legislature actually intended to override every single the law that was on the books before. And that doesn't seem to make any sense in light of what we absolutely know for sure about the regime.
Well, so Urmansky's argument is that the legislatures of the state of Wisconsin, right, were doing all that work for only one reason, and they would never have done it otherwise. And so if we're going to guess about which is which, then we're just guessing, and the implied repeal doctrine, clarity in the law, notice, all say that it's the earlier law that must fall. But if Your Honors, and we don't think there is a need to consult that legislative history, but if Your Honors want to, if you think that there is, that further supports our argument, because the best that Urmansky can offer you is that we didn't expressly repeal 940-04. Again, we know that. What you'll find in the legislative history, in addition to what we cite in our brief, that reflects that Wisconsin expressly considered including a provision that said that 940-15 could not be read to impliedly repeal 940-04, but did not, is piece after piece after piece of legislative history reflecting that 940-15 was absolutely intended to be a replacement for 940-04. An example is at 657 in black, this court discusses memo number 22 from the 1985 Special Committee. And of course it was intended to be a replacement because the statutes are doing the exact same work, but they provide directly opposite answers. And just to briefly respond
also, you are presenting the repeal by implication doctrine as if it's something that has good grounding in Wisconsin cases. It doesn't. You acknowledge that we have expressed as a court, going back decades upon decades, that the doctrine is disfavored, and only in very limited circumstances would it be applied. And you keep talking about there's a conflict between the statutes, but I think your friend on the other side has laid out quite clearly how it is possible to comply with both. We also have numerous cases saying if you can comply with both statutes, that there isn't a conflict, right?
You can't comply with both because 940-15-2 would be doing no work. And so the question of possibility to comply with both asks whether both is doing work as a statute. But to Your Honor's point about the disfavoring of implied repeal, this court in Christensen, as an example, has recognized that there's an even more important policy, and that's one that I know Your Honor understands full well, and that is the importance of providing clarity in the law where there's any doubt to the people so they can know what is and is not subject to criminal sanction. And I would just stress one other point about the possibility. Urmansky tries to impart the impossibility standard of whether it's possible to comply with both from the first form of implied repeal onto the second, but that's not what the second form of implied repeal asks. The second form of implied repeal asks whether the legislature, and I see my time has expired, may I
Go ahead and finish.
Thank you. Whether the legislature has enacted a new comprehensive regime that is fundamentally at odds with a law banning the regulated behavior. And so as the federal court explained in the Bentley case we cite, under the second form, even if the terms of the old law and new regime are not expressly repugnant, the later act will operate as a repeal if the later act covers the whole subject of the first and embraces new provisions plainly showing that it was intended as a substitute. And that is also what has happened here in Wisconsin. Thank you.
Thank you.
Madam Chief Justice, and may it please the court.
So, Attorney Welsh, I want to jump right in, and that's because I wasn't able to adequately get my question to Attorney Jers, okay? I want to talk to you a little bit about the implied repeal, and maybe you can help me understand it a little better. My belief was that if we embrace implied repeal here, Black has to be overturned. Can you specifically tell me whether you agree or disagree with that and why?
I agree with what Justice Karofsky hinted at, is that implicit in the Black analysis was some type of implied repeal. You know, this court in Black, considered what work 940.04 was doing in light of 940.15. That seems an awful like an implied appeal and repeal analysis. So I think there's, as we explained in our brief, we think there are a few different paths to get us to the place where this court affirms the circuit court decision.
My understanding, I think you like the, and correct me if I'm wrong, I think you like the implied repeal argument better, correct?
I think the implied repeal argument is more intellectually sound. I think that
tell me why you think that.
As discussed by my colleague, Attorney Jers, we do need to look at this old statute, 940.04, and when a legislature creates a new statute, and it was not required to create a new statute. Neither Roe nor Casey nor any other Supreme Court decision said, state legislators, you need to take these laws off your book and you have to go write new statutes. Instead, more than a decade after Roe was decided, the Wisconsin legislature put together a study committee to examine pregnancy options, and they produced 940.15. So now 940.15 and other statutes were created that discuss under what circumstances abortions could be lawfully provided in Wisconsin and when they were unlawful. So that can no longer be reconciled against 940.04, which was a virtual ban on all abortions in all circumstances. And then following 940.15, in the last 40 years, the legislature has passed numerous other laws that affect abortions, including when minors can obtain an abortion, under a judicial bypass system when they cannot get parental consent, when medication abortions can be provided to patients. So the entire field of discussion about abortion has been replaced. We're not in unlawful conduct, we're in regulated conduct.
Counsel,
that's why I think an implied repeal argument more fully addresses the basis for this court. And I also think, as we discussed, there are constitutional concerns under void for vagueness and due process that our clients, the physicians, think should be addressed as well.
Thank you. Go ahead.
Counsel, Black says, further, when the legislature enacted 940.15, it did not repeal 940.04 2A. Instead, both 940.04 2A and 940.15 remain the law. Nothing persuades us that the legislature intended to impliedly repeal 940.04 2A when it enacted 940.15. Implied repeal of statutes by later enactments is not favored in statutory construction. So Black held, and that was necessary to its holding, that implied repeal did not occur. Could you square that for me? I mean, think if you accept implied repeal, I think to Justice Prosewicz's question, you would have to overrule Black on that ground, would you not?
And then you should overrule Black on that ground.
Say that again.
And then this court should overrule Black to the extent it's saying otherwise.
Right.
And
if we adopt Black, we have to overrule McGreeson's, because McGreeson's authoritatively interprets 940.04 sub 1. So it seems to me under either argument, you need to overturn some cases if you're going to accept your position. Is that correct?
Yes, because the legislature has spoken and they've laid out a myriad of statutes that govern when abortion can be provided, when women in this state can obtain lawful abortions.
Is it possible, though? I mean, look at the date. Black was in 1994. At that time, there wasn't this entire comprehensive scheme that has been since enacted. And could it be that the language of Black that is an implied repeal type language now, when looking at that and looking at today and looking at the framework, that the court could reach a different conclusion without having to overturn Black?
Yes, and I think we're not looking at just one statute or two statutes that were in conflict with 94004, but again, a whole comprehensive scheme of abortion statutes.
Which is
since 1994.
And indeed, in Black, there was no reason to look at 94015 other than to think of it in some kind of implied repeal setting. But that was 1994 versus now and versus the entire structure that's been laid out since that time. Is that how we could possibly reconcile those concepts together?
Yes, and then I think we can look at what the legislature has or has not done since Black. They did not statutorily overrule Black. They didn't say, hey, court, you got it wrong. We don't think this is a feticide statute, and now we're going to put in a trigger ban. We were going to put in a trigger law that says that if the U.S. Supreme Court ever reverses Roe, we actually do want 94004 to apply to consensual abortions again. That didn't happen. And there was discussion about what West Virginia did, and I think that's a very good example of a state with a similar abortion history to Wisconsin. But the legislature there did not acquiesce. Rather, it has taken numerous affirmative steps post-Dobbs to pass a new abortion ban, passed in part on a court's finding of the implied repeal of the 19th century law. So they had a pre-Roe law that remained on the books since the 19th century. It was found unconstitutional shortly after Roe was decided, but it was not repealed. Then in July of 2022, so shortly after Dobbs, providers secured an injunction barring enforcement of the old ban based in part on the implied repeal doctrine. In granting the injunction, the court found the providers were likely to prevail on their implied repeal argument based on the legislature's passage of numerous laws governing abortion care. So again, very similar to Wisconsin. Just a few months later, the West Virginia legislature passed a near total ban. In 2023, West Virginia also enacted a new trigger ban, establishing that if the state's 2022 total ban was ever determined to be unconstitutional, the state's 20-week ban, disability reason ban, informed consent, and parental notification requirements would all take effect again. And I think this is important to think about. When the U.S. Supreme Court issued the Dobbs decision, Justice Alito made clear that they were sending the decision back to the states and state legislators. State legislative bodies could make these decisions, and by sending it back to the state, it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office.
Counsel, you're disagreeing then with the Attorney General's position. As I read the Attorney General's brief, it was doubling down on Black as their primary argument. Then they had an alternative argument of impliedly repeal. So you're standing here today and saying the doubling down on Black done by the Attorney General is wrong.
I think the circuit court was correct in applying State versus Black. It is a decision of this court. It couldn't ignore it.
Answer my question.
Yes. I think these are two paths to get us to the same right answer, that either Black versus controls and using this court's analysis in State versus Black, the same reasons that subsection 2 is feticide should apply to sub 1. Alternatively, if you use a more straightforward implied repeal analysis, which makes sense to me personally, then we still get to the same place, that the legislature has acted numerous times with intention based on the language that they passed to create laws that make it lawful for women to obtain abortions in numerous circumstances and have regulated how and when physicians can provide those abortions.
What part, does any part of 94004 survive the impliedly repeal argument? For instance, sub 5, is that impliedly repealed?
No, and I think that's It applies only to the extent that it remains a feticide statute. So sub 5 doesn't do very much work in a feticide statute, perhaps, but to the extent it would apply just like the other feticide statutes. We're not talking about consensual abortions.
So just if I may finish so all of 94004 is impliedly repealed, or just sub 1, 2A? I mean, what parts? All or nothing?
All of it has been impliedly repealed, has an abortion statute. To the extent that it's doing separate work, has a feticide statute, it's not essential to impliedly repeal that.
Thank you.
The last person in the room I would want to disagree with is Justice Ann Walsh Bradley. But do you read the Attorney
So
General?
go with your instincts.
I'll regret this later. Do you read the Attorney General's brief the way Justice Ann Walsh Bradley characterized it? I'm just not sure I did, and I didn't see. I saw them laying out the Black argument first, and then the implied repeal, but I didn't see them. And this must be so painful for you, Attorney Juris. If I were you, I'd want to just grab that microphone. But I didn't read the briefing that way. I read it as what you just said, that there were two ways to get to the same answer.
Justice Krosky, that has long been my understanding of their position since the Circuit Court and in their briefing today.
And in the argument today as well.
Yes.
Correct.
And can I ask a question about the injunction? There was an injunction that I believed your clients asked for in the trial court. Are we done with the injunction? Is that still a live issue? What, if anything, would you like us to do with the injunction?
If you declare that 94004 is not enforceable against healthcare providers providing abortions, then no injunction should be needed. That should be the law of the land that controls the actions of prosecutors across the state. We wanted to be clear that we avoid any problem of a declaration only applying to the parties in the case, or versus subsequent district attorneys or district attorneys and other counsel. But we believe that's been clarified, and we think any decision by this court certainly will be the law of the land, which would negate the need for a separate injunction.
Right. Okay.
Counsel, did I understand you to say that 94004 sub 5 survives and applies to feticide?
I think it's not really relevant to feticide. I don't think it's going to be doing a lot of work. But again, I think the important part here is that has an abortion statute, all of 94004 is impliedly repealed.
The section says this section does not apply to a therapeutic abortion which A, is performed by a physician, and B, is necessary or is advised by two other physicians as necessary to save the life of the mother, and C, unless an emergency prevents, is performed in a licensed maternity hospital. How could that possibly have any application to an interpretation of the statute to limit it to feticide?
I agree.
So do you agree then that the statute that section is about abortion?
I agree that we've never argued against the notion that when 94004 was drafted, it was about abortion.
So, but if you're making an argument about black, then you're arguing it somehow is no longer about abortion?
Right. When the legislature in 1985 passed statutes that covered the exact same conduct, that it replaced 94004.
So that's an implied repeal argument. Let's put that aside for a moment. I understand that argument. But if we're not talking about implied repeal and we're just talking about black, then we're just talking about what the statute says. So a statute that says it's about abortion, titled abortion, case after case after case for 100+ years, and this court said was about abortion. What you're arguing is that we should take black's statement about subsection 2A, apply it to subsection 1, overturn all these other cases despite the plain language of the statute, and just say it wasn't about abortion. Putting aside implied repeal, I'm talking about the black argument here.
That's one possible way to affirm the circuit court, and that's what the circuit court did.
That's we're trying to get it right, I hope, not just get an outcome here. So could you make an argument to me that the statute is not about abortion?
The statute was about abortion when passed. Again, applying Black, the circuit court said it's not about abortion. We think another approach is the implied repeal.
Right, that's implied
argument.
repeal, but you
And-
did make both arguments. So I want you to put implied repeal aside for a minute. Please just focus on Black. And you're making a textual argument. You'd have to extend Black's reasoning, overturn some cases. So make for me a textual argument that 940.04 sub 1 is not about abortion.
The circuit court followed the rationale that was set forth by this court in Black. It's not at liberty to replace, the logic and holding of this court with its own.
Well, in
decision.
Negreeson's, this court said 940.04 sub 1 was about abortion and defined the elements and called it an abortion statute.
Despite the language being, practically the same as sub 2.
Right. So, the circuit court applied a different statute than what this court authoritatively has construed sub 1 to mean. Right?
Again, that's not the argument we're leaning into. I think we set forth in our brief.
It is one of the arguments you made. If you want to abandon it and say it's not a good argument, then feel free to do so. That's always helpful when we have aren't sound.
I think the physician's stronger arguments are the constitutional concerns that are raised, that there's a lack of fair notice and due process caused by trying to revive a law that hasn't been enforced in more than 50 years, where there's a whole new body of abortion statutes that have been enacted in the past 40 years. I also think it's important to look at the legislative policy decisions that they have made over the past 40 years. We don't need to look about what the legislature thought was important or appropriate in 1859 or even 1955. We need to look at what the legislature did over the past 40 years and consider the will of the people. The legislature is acting with the consent of the governed. That's all of us in this room, not whoever voted for the legislature in 1859 or 1955. Public views on abortion have shifted dramatically. So you might say the legislature only did these things because of Roe, but the legislature maybe hasn't taken any other action since Black or since Dobbs because it is honoring the will of the people.
Could you address the facial challenge point? As doctors, representing the doctors of the situation, you are attempting to argue in your constitutional arguments that all of 940.04 be struck down. Again, putting aside applied repeal, it's a different argument. Your constitutional arguments. The counter here is that the law is pretty clear that unless it's unenforceable in all its circumstances and situations, that your facial challenge would fail. And there's certainly seems to be lots of examples that don't fall into even some of the scenarios that you might adopt where there's any kind of lack of clarity. So how can you win on your facial challenge?
Yes, District Attorney Romanski's argument that we cannot establish a valid facial challenge unless it applies in all circumstances ignores the language of Johnson versus the United States and overstates the Seventh Circuit's analysis in Planned Parenthood of Indiana versus the Marion County prosecutor. In the former, the Supreme Court has stated that its holdings squarely contradict the theory that a vague provision is constitutional merely because there is some conduct that clearly falls within the provision's grasp. The Seventh Circuit discusses Johnson. Its actual holding is based on the principles of federalism, where it says the federal courts should not step into the matter yet before state agencies could provide additional pre-enforcement guidance, and that it was the purview of state courts, not federal courts, to interpret and limit statutes as necessary to provide fair notice and due process. Stating the obvious, we are seeking a declaratory judgment in the state Supreme Court, and it is appropriate for this court to interpret statutes such that they do not offend state and federal constitutions. D.A. Romanski relied on State versus Conrath, which deals with an overbreadth claim, not a vagueness claim, and he erroneously relies on civil cases, including Gabler versus Crime Victim Rights Board, which simply cannot stand for the proposition that vague criminal statutes are immune from this court's review. I see my time is up. May I finish my point?
Have you finished?
I have one more.
Go ahead.
State versus Christensen instructs us that penal statutes should be strictly construed to provide fair notice to defendants. Thank you for your time.
Right, thank you.
Good morning. I'm Sam Lieb, and I have the privilege of representing John Chisholm, the District Attorney of Milwaukee County, who is now passing the mantle to a newly elected District Attorney, so likely this will be his final appearance in his official role here before this body. Our submission was limited. There are a number of concerns that he had, primarily preserving prosecutorial discretion. But there are a number of points that I wanted to make, and not to repeat what others have said, because they've done a very fine job in their briefing and also their discussion. District Attorney Chisholm does not agree with the position taken by Defendant Urmanski. Obviously, it's the largest county in Wisconsin. That's important. There is a legion of other district attorneys who do not agree with Mr. D.A. Urmanski's position, and you've read the Amicus brief that was filed by the Prosecutors Association. The fact that the issue of unclarity, probably these proceedings is a pretty good example as to how unclear it is, and further supporting the lack of clarity to the statutory scheme is the fact that D.A. Urmanski is the only one who is a voice for his position.
Counsel, I want to address in your time that's short here, I'd like you to address, I think you made a really important point, and we didn't get to it with Attorney Urmanski's argument, but how the Attorney General has the authority or standing here to step in and bring this lawsuit. You made a point that the Attorney General has no supervisory authority or control. The District Attorney of Milwaukee is elected by the people, has prosecutorial discretion. Same with Sheboygan, same with Madison. So could you just address that argument, please?
Quickly. We believe that argument is somewhat moot in these circumstances, because once the interveners became parties and Judge Schlipper acknowledged jurisdiction at that point in time, that was not an argument that was necessarily pursued. But regarding prosecutorial discretion, it's a really important tool that district attorneys have. District attorneys need to have clarity in laws in order to apply their prosecutorial discretion. Prosecutorial discretion doesn't allow for legislation. It doesn't allow for remedying laws that aren't clear, and obviously prosecutorial discretion is not informed by faith or political position, and that's the problem. And the position we have taken in this is that the interveners certainly had standing, so the standing issue was somewhat mooted by their inclusion in the case.
You're not reading the Attorney General's brief here to say that they are going to somehow eclipse your client or the other 70, I believe it is. 71. I think there's 72 counties. I think there's 71 district attorneys because Sean O'Menominee is one. It's your random fun fact for the day. But I'm not exactly sure what you're arguing. Are you arguing? I don't think it is. I don't think what you're saying is, look, the Attorney General, I don't think what you're saying is that you are reading the Attorney General's brief and listening to the arguments today, and that somehow by coming here and asking us to either overrule Black or to find that 940.04 was impliedly repealed because of 940.15, that by doing that, the Attorney General call is somehow infringing on District Attorney Chisholm's or any of the other 70 district attorneys' prosecutorial discretion. Are you?
No.
Okay.
Our concern initially was that somehow, either the trial court or before this body, this would be, the decision would be couched in terms of some effect on prosecutorial discretion. And it shouldn't be, because this is not a clarity issue with a statute or a statutory scheme that should be subject to resolution somehow by prosecutorial discretion.
Right.
That was the concern in that regard.
So I just want to make sure I understand what you're saying, and correct me if I'm wrong. You're saying in a world where 940.04 and 940.15 are both alive, that it is very, very difficult for prosecutors to apply their discretion in that case?
Yes.
Yes.
In fact,
okay. All right. I didn't mean to be Captain Obvious. I just wanted to make sure I understood what you're saying.
Yes, if they were both alive. If Judge Slipper's decision were overruled and these were both alive, yes, it would be. And our brief also notes that Judge Slipper's decision is a workable decision. What she ruled is workable. The last comment I wanted to make is the criminalization of potentially standard of care treatment by healthcare providers is very problematic. As Justice Karofsky indicated, what are they supposed to do? And it is extremely problematic. The pregnancy obviously is a circumstance that is somewhat reserved to obstetricians and some other healthcare providers. The ability to provide standard of care treatment and to suggest that should be criminalized is very problematic.
Isn't that discussion before the legislature, though? I mean, is it really the call of this court today to make sure practitioners know what they can and cannot do? The issue here today is 940.04 and whether that's still on the books, really.
Yes, but ultimately, the effect of that is to either acknowledge a chilling effect on the healthcare community, which ultimately deprives a pregnant woman of her right to choice or not.
I understand what you're saying, and I also understand a whole host of sympathetic facts that would trouble anyone. Having said that, the issue before this court and the requests that are being made are sometimes two different things that I'm hearing today. The issue before this court relates to 940.04, whether black rules, whether it's impliedly repealed, whether it's still on the books. It won't answer every question for everyone today. People need to be before the legislature and ask them to do their job.
Well, certainly. But the confusion
just so long
that
as we don't have this perception that this court is the legislature.
No, and neither are DAs. And the confusion that exists currently is a very serious circumstance, both to the healthcare community, but also to pregnant women. Thank you.
Thank you.
Chief Justice, and may it please the court. Just as DA Ermansky has an opinion on what the law currently is with regard to abortion, so too does Dane County District Attorney Ishmael Ozan, and likely many of the other 69 district attorneys statewide. Ozan believes the circuit court's interpretation of 940.04 sub 1 and its reliance on black is the most appropriate and logical interpretation of the statutory text, and is the easiest and narrowest way to resolve this case.
Even though black specifically said it wasn't dealing with that section.
Could you repeat that? I didn't quite hear it.
Even though Black specifically said it was not dealing with that section.
Your Honor, the language at issue here today in 940.04 sub 1 is effectively identical to the language that this court reviewed in Black 30 years ago. There is no reason that that same language shouldn't also apply here.
Well, perhaps because we held it means abortion.
Your Honor, I'm not sure which cases you're talking about, but if you're
State
talking
v. Greason's, and it was applied to abortion. Subsection 5 has an exception that says abortion. You don't have to rely on statutory titles, but if you want to, it says abortion. Everyone, even your counsel on your side of the table, said, yeah, we all agree it was an abortion statute when it was first adopted. Case after case after case says that. The idea that statutorily this is an abortion statute, I mean, I don't mean to overstate the case, but that seems incredible to me that one could make an argument, apart from Black, which didn't even really interact with the statutory text in a meaningful way, that this 940.041 wasn't about abortion.
Sure, I have a couple points in response. First, I would say I think we disagree a little bit about what the Mack, Gressens, and Cohen cases do. They were never thoroughly interpreting the statutory text in the same way that the Black case was, and these cases were 30 years before the Black case was decided and dealt with a defendant raising alleged trial errors on appeal. I will also just note that in Black, the court looked at the plain language of 940.04 sub 2A and said the words of the statute are plain and unambiguous. They could not be clear. It is not an abortion statute. It makes no mention of an abortive type procedure. That is the same language that we are seeing in 940.04 sub 1. There is no mention of an abortive type procedure, and that's why Black is dispositive here.
Do you think if you went to any person on the street and said, let me read you something for a minute, do you think the intentional destruction of unborn life, that language, would apply to an abortion?
Your Honor, I'm going by what this court said in Black 30 years ago.
I know,
and
but
how
it also,
it interpreted the text.
But it also said, I mean, in case after case after case, it did apply these to abortion restrictions. It was prosecuted as an abortion statute. I mean, everybody knew it was an abortion statute. It was the statute that the federal court said was unenforceable pre-Roe and post-Roe. Everybody called it an abortion statute. And up until the circuit court, everybody knew it was an abortion statute,
That's not.
But, Your Honor, the court interpreted this same exact language in Black in 1994 and said it does not describe an abortive type procedure. This is a feticide statute, plain and simple. This court would have to overrule or distinguish Black to find any other reading of 940.04 sub 1.
Would you agree that if we accept Black, we'll need to overrule or distinguish all kinds of other cases and disregard some of the other plain language in the statute?
I disagree with that. I don't think you would have to overrule any other cases if you affirm Black.
What is your... Go ahead.
Are you familiar with 2927 or 29275, where the exact same definition that is used in 940.04 is used in those statutes that were enacted considerably later, dealing with subsidies and fundings for abortion? Exact same words define abortion.
Am I familiar with those statutes? Is that the question?
Well, you agree that the exact same terms define abortion.
Which statute, Chief?
2927, 29275.
I'm not familiar with when exactly those statutes were enacted. I do just want to make one or two final points. One about dicta.
They define, just to finish, they define abortion as the intentional destruction of life of an unborn child.
Chief, I'm sorry, I don't see a 2927 in the statutes.
I can give you a copy later if you'd like. 20.9275, 20.927. And those were enacted significantly later, 1997, I think, 1977. There are a whole host of statutes that are at play here. This is not a simple statutory scheme by any means, in my opinion. But that's been the definition of abortion. The statute's labeled abortion. It was subsequently modified even after, in 2011, in light of, it seems, 940.13. and certain things were taken out of 940-04 to comply with the then statutes that were in place. But guess what? They left in 1 and 2 that were always understood to be abortion statutes.
I think, I see my light is out. May I?
You may
I
answer.
have to leave to respond. I guess it would just be the same thing that I already said. To say that lots and lots of cases have said 940-04 sub 1 is an abortion statute, I think overstates it. And it was more of a drive-by interpretation or a court reviewing a criminal trial on appeal. I think that the Black case is dispositive here, and there's no reason that every component of Black's rationale with regard to 2A should not apply with equal force to the nearly identical language in 940-04 sub 1. Thank you.
May I please ask one question I didn't have a chance to ask? Thank you. I want to ask you about 940-04 sub 5. Can you help me understand how that fits into your argument? And imagine that in giving your answer, you don't have to rush.
940.04 sub 5 is a little problematic, I'll admit that, because the Black course did not deal with that subsection, even though it did look at the context. I would point you to the state's brief, which I think dealt with subsection 5 pretty thoroughly, and I believe its page is 52 and 53 of the state plaintiff's brief. Thank you.
Thank you.
Thank you.
I'll begin by responding to the argument by doctors regarding fair notice and whether or not this is an unconstitutionally vague. And if you give me 1 second, I'll raise the podium so that everybody can hear me. Regarding the standard that is applied to a facial unconstitutional vagueness challenge, they're correct. The United States Supreme Court in Johnson said, no, we don't apply this standard where just because you can identify some application that would be constitutional, the statute stands. But the reality is, even under that standard, if there's a clear-cut core of conduct to which a statute can be applied where the vagueness concerns would not arise, the statute is not facially unconstitutional. Here there plainly is elective abortions for otherwise healthy mothers early in term, which, it's not in the record.
Not healthy. It's whether or not they're going to die. There's nothing about health of the mom. We went through this. I mean, unless someone is going to die, and I don't really know where that line is, and I would be willing to challenge any OB in the country that they don't know where that line is. It doesn't say health of the mother. It says life.
And Justice Karofsky, the point I'm trying to make is that many people obtain abortions for reasons unrelated to health. And there is a clear-cut core of conduct. People who get elective abortions...
Let's talk about the reason. Sexual assault, right? Someone might want to get an abortion because they've been sexually assaulted, right? 65,000 people in the 14 states where abortion was made illegal after Dobbs. 65,000 people became pregnant. So all of those people might want an abortion, right?
And Justice Karofsky, you're talking about the policy implications of the statute. And
you know what? I'm talking about real life. I'm talking about the implication of what these decisions have on women and children and pregnant people in this state. That's what I'm talking about.
And Justice Karofsky, I think the legislature is the proper branch to take into effect those policy considerations. The point I'm trying to make is that when we talk about vagueness and about drawing the line as to whether or not something is necessary to save the life of the mother, you don't have to get that here. This is a facial challenge, and the reality is there are many abortions that are performed where the woman's life is not in danger and where the woman's health is not in danger. There's a clear-cut core of conduct to which the statute can be applied without raising any of these vagueness considerations. That's the point I'm trying to make.
You are unable to make your argument without talking about the health of the mother. It's the second time you've done it in the last 2 minutes. It's an almost impossible. I don't think you can thread that needle. And you've tried it twice and you haven't been able to do it, and that's the point.
Justice Karofsky, the point I am trying to make is that, as I understand the doctors, they are raising their vagueness challenges, saying sometimes we can't draw the line between health and life. That's the point they're trying to make. And the point I'm trying to make is that there is a clear-cut core of conduct that is so far removed from that call between whether or not it's health and life. Because there are many abortions that are performed that don't even get into the realm of health. That's the point I'm trying to make. And because there's that conduct, and it is a clear-cut core of conduct that doesn't even cross the line into health, so you don't even get to the question of whether or not you're between health and life, that a facial challenge necessarily fails here.
Right, and under that umbrella are 65,000 women. Under that umbrella is carrying a fetus that has a fetal abnormality, right?
Justice
Victim
Karofsky,
of incest?
I'm not the legislature. And I guess the additional point I would make is State versus Wood makes very clear that you don't take up a facial challenge when the plaintiff, the statute can be constitutionally applied to the plaintiff. The only party here that has any standing at all is Dr. Lyerly, who performed abortions in Sheboygan. There's no justiciable controversy between any of the other plaintiffs and any of the other DAs. They're on the same side. And the reality is, Dr. Lyerly says in her affidavit that she performs elective abortions. So under State versus Wood, you don't even have to get to any of this facial, unconstitutional vagueness questions that the physicians are raising. And I guess the last point I would like to make is that when we talk about implied repeal, we're talking about one of the most anti-democratic things this court can do. It is anti-democratic. It's a statute that the legislature has not repealed, and this court is saying, no, you actually repealed it, even though you didn't. And I can't cite a single example, and nobody else has, of a case where this court has held that an implied repeal exists where the legislature actually had a provision in a draft of a bill expressly repealing the statute and took it out. It's never happened before. This would be unprecedented. And in fact, it would go against this court's precedent in Connolly, where this court said, if you considered it a repeal, you didn't do it, it's not for this court to do what the legislature's chosen.
So what about Matthew A.B.?
Say that again?
Matthew A.B. That's a case where we found implied repeal based on the conduct of the legislature, which when you propose it's anti-democratic, it's also anti-democratic to disregard legislative policy for decades, to go back to legislative policy from 1849. But are you familiar with Matthew A.B.?
I'm not, Justice Stalin.
Okay, it's a case involving Chapter 980. It's a case involving how to interpret what is very clear law from the older law, which said you cannot involve juvenile adjudications when you're using 980 later on. And 980 created a comprehensive scheme that allowed you to use the juvenile adjudications, and this court found that that was impliedly repealing an older statute.
And I'm not familiar with the facts of that case, but I guess if my point is, in that case, did the legislature have an earlier draft of the statute that would have expressly repealed
Took it
out?
We talked about this because you didn't just have what you're saying, you also had an express bill that would have said that this does not impliedly repeal, and they didn't pass that either. So you have, if you're going to look at legislative history, you have to look at both of those.
Justice Stalin, I am, and I see a tie. And in this situation,
then you can't use it.
The burden is on the party seeking implied repeal.
That Matthew A.B. had a good dissent. You should read that sometime. I want to ask, I see in black, it says, when the legislature enacted 940.15, it did not repeal 940.04(2)A. Nothing persuades us that the legislature intended to impliedly repeal 940.04(2)A when it enacted 940.15. You agree with that, don't you?
It certainly did not intend to impliedly repeal 940.04.
Yeah,
correct.
so you agree with that part of black.
And correct.
But you disagree with, when I look at black, I'm taken by the group that says, the group, I mean the esteemed justices who are in the majority, who were Wilcox and Steinitz and Bablich and Day and Justice Geske, right? And all of them, after looking at this case very clearly and several times said, this is not an abortion statute. The clear and plain language says this is not an abortion statute. So those 5 justices, the majority, coming from what one may argue as a myriad of backgrounds and views of life, looked at it, and not just once, not just twice, but reiterated in its short opinion. The language is clear. There's no doubt about it. This deals only with feticide. It is not an abortion statute. But you're saying they're wrong. Is that correct?
I think under this court's recent decision in Waukesha County versus MAC, that decision was unsound in principle. They didn't undertake a comprehensive examination of the statute or consider relevant subsections.
We use unsound in principle as fancy language. They're wrong, is what you're saying.
Yes, they're wrong.
And it pretty clearly says we address only 940.042A and make no attempt to construe any other sections of 940.04.
That's correct, Chief Justice Ziegler. Not only did they not undertake a comprehensive examination, they were pretty open about the fact that they weren't undertaking a comprehensive examination.
I thought your position in your brief, correct me if I'm wrong, was that there's no material difference between the 2A and sub 1. Wasn't that your position in your brief?
I believe that was the position of the circuit court below and the position of the respondents who are arguing for that position to be affirmed. Our position is State versus Black clearly didn't overrule the prior precedents of this court applying 940.04 sub 1 in the context of abortion. So if we're applying the right precedents here, those are the precedents that apply.
The difference between the two is the use of the word quick or quickening. Did that make a material distinction for purposes of analysis in your mind?
I actually think it does. And the reason I say that, Justice...
In your brief, you indicated that it didn't.
Well, Justice Bradley, I think it made a material difference in the Supreme Court's reasoning in Black. And I see my light is on, but if I could finish my answer to this particular question. In Black, the court was applying the harmonious reading canon. They were saying we have to read these statutes in a way that they don't conflict. Our position, obviously, is there's actually no conflict here. But here's the important point. They never even recognized a conflict with the application of 940.04 2A to a pre-viability abortion. So even if you took everything that Black said as, correct, they're avoiding this conflict. The only conflict they ever identified with respect to pre-viability was Roe. And Roe has been overturned. So even under the reasoning of Black, we believe you could apply 940.04 to an abortion in the pre-viability stage. Thank you.
Okay. All right. Thank you very much. We have concluded oral. The court is adjourned. We will convene at 12:45 in conference.
You have been watching a production of Wisconsin Eye, your unfiltered window into legislative deliberations and public policy programming, where our mission is to provide Wisconsinites an opportunity to access the legislative process and connect with conversations that inform our citizenry. Please consider supporting our mission, and thank you for watching. Wisconsin Eye, policy made public.